Welcome to the Biz Bash podcast, where we make biz strategy a piece of cake. I'm Elizabeth.
And I'm Cami, but you might know us better as Eliza Ann Calligraphy and Cami Monet. We want to help you, our fellow stationers, artists, and calligraphers, confidently build a profitable and personality-driven creative biz.
We're here to share our honest-to-goodness advice and actionable strategies for ambitious artists.
So put on your party hat, quit being a procrastinator gator, and let's get this party started.
Hey everyone, welcome back to the Biz Bash podcast. This is Elizabeth here, and I'm of course with Cami, but today we have a very special guest for you guys. Her name is Andrea, and she specializes in copyright and trademark services for creatives. So we are very excited to welcome her to the show today. Welcome, Andrea. We are so glad you are here.
Thanks for having me. I'm really excited.
We are so excited to have you, Andrea. You are our first guest, so this makes it even more exciting. And we just can't wait to pick your brain about all things copyright and trademarks. There are so many questions we get about this, and we thought we should bring in an expert who can really give us all the details we need about legal side of copyright and trademarks.
Yeah, absolutely. I'm ready.
Perfect. Before we dive into all of that stuff, because we have some great questions from our audience for you, I just wanted to ask you how you got your start in law, and then what kind of drove you to working specifically with creative small business owners, and when did that change happen for you? We'd love to hear a little bit about your story.
Yeah, so I went to law school. Actually, I was going to law school to be a JAG officer in the Army. I did ROTC in college, and then I wanted to go to law school, and I was like, okay, great, I'll be a JAG officer. And then my husband, who also was in ROTC with me, he was planning to be active duty as well and just follow me wherever I went. Well, long story short, that changed, and he ended up getting a job within the state of Kentucky. So he was active duty within Kentucky. And so that kind of changed paths for me because we didn't want to be separated our entire career. So then I said, okay, well, I'll just, get a regular job, in private practice, whatever. So while in law school, I also started my own women's clothing boutique. So that's pretty much what got me started with a small business, having my own business, having the boutique, making great relationships with other small business owners. And when I got the job that I had at a big law firm, I was just started to reach out and try to sell my boutique because I knew I wanted to be full-time law. Well, in that kind of transition period, I realized that I did not enjoy working at a large law firm, and it was just nothing but large businesses. They didn't care who I was, and I loved having my own small business, and I loved working alongside other small businesses, whether it just be something friendly like, oh, how's your business going today, or just being around other small business owners. That's really what ignited me and really what I was passionate about. So I was only at that firm for about 7 months. And before I left, I actually had this one instance where I was bringing in a boutique client. She needed a trademark. And whenever you bring in a client, you have to go through this whole process of they have to basically vet the client, make sure, everything's fine. They just have their own process. Well, the client was, a kind of a big small business, multi six figures, didn't have an issue paying the rates at the, of the firm, which were pretty high. Well, the partner that I was working with to bring in the client basically berated me for bringing in this so-called low quality client. And I was just so baffled that just because they were not a million or billion-dollar client. They didn't want them and they didn't care about them. So from that moment, basically, I was like, okay, this is not the place for me. I definitely, I want to work with small businesses. So literally a month or two later, I left, went out on my own. At that point, we were in Kentucky and we moved back to Houston, and we have been here ever since last May. And being able to go out on my own and really work with small businesses, I started with a big network in the boutique world, and then that's kind of branched out into other creative businesses because I've seen firsthand the gap between quality legal services and small business owners. Like there's a huge gap there, and I know it has to be filled. So that's what I've been trying to do for the past, I guess, 8-9 months, and it's been awesome. It's been a dream come true, and I'm really excited that I can really just close that gap and be a good go-to resource for creative entrepreneurs.
Yeah, that is an awesome story. And we're so glad that you are able to close that gap because Lord knows I know in the creative industry, we all just get like heads over tails about legal stuff. And it scares us because our brains just don't work with that in that way. So it's really nice to have a resource like you to be able to reach out to. And yeah, we're excited to have you on board. So your story talked a lot about like how you wanted to start helping out small businesses, and a lot of small businesses, we don't even know where to start. So let's break it down super simple. Can you just kind of give us the gist of what the difference between a copyright and a trademark actually is? I hear those words thrown around and they're used for the same thing when I know they're totally different. So can you just break that down for us?
Yes, absolutely. Yeah, those are pretty much two of the most misused terms, I think, by small business owners. Even in Facebook groups, I spend a lot of time in Facebook groups, and so many people are, you see all the people like, oh, what do I do for this? And, somebody stole this picture from me, or somebody stole this design from me, or somebody's using the same business name, and everybody's just throwing in their 2 cents about copyrights and trademarks, and they have no idea. But yeah, so it can be very simple um, to really just know the difference. So to break it down really easily, I like to just tell people copyrights equal the creative works, and that means your photography, your designs, your books, your content,
Right.
your online courses, the content in there, all that can be copyrighted. Your, videos that you create, all the content, all your creativity, that is all covered by a copyright. So to break it down into a simple one word, copyrights equal creativity. And then for trademarks equal branding. And that is anything that identifies your actual brand. So most common you think of is your brand name, and then your logo and your slogan. So those are the three most common trademarks. And those are really, that's really the easiest way to break it down, is to know that copyrights equal the creativeness, and then the trademarks equal the branding.
That's honestly probably the best I've ever heard that defined. And I think our audience is going to love that. I did want to follow up and ask a quick question. People can trademark other things, right? Because and this is like, I'm pretty like naive about law stuff, but I think I remember hearing that the phrase wifey was trademarked at one point. Like, people put that on mugs and t-shirts and all these different types of things. And somebody had actually trademarked that. So would they have trademarked it as like a slogan to try to put a claim on that? Like, where does something like that lie?
Yeah, so a lot of people are actually trying to get by with, I don't want to say fraudulent trademarks, but basically what shouldn't be allowed as a trademark. So like the whole, phrases on the mugs, the t-shirts, that's very popular right now. And everybody wants to trademark, a phrase, that way nobody else can use it. But that's not actually eligible for a trademark. And some people do slip through the cracks. But they they will soon find out that they have wasted their money, because the trademark office is actually cracking down on it, and they are coming up with a streamlined process to start canceling those. They call it it's what the trademark office considers ornamental trademarks.
Okay.
Or ornamental designs. They're not eligible for trademarks because it's merely for decoration. It doesn't actually identify a brand. Now, there are some people, or there are some companies that do have actual phrases that they have created into a brand. Now,
Yes.
if
Okay.
that is eligible for a trademark, but I see so many times people, I mean, I get emails all the time. Hey, I want to, trademark this, this phrase on my t-shirt or mug. How do I go about that? And I just tell them, sorry, it's not eligible for a trademark. You have to, they're for branding purposes. And if you're just using it on a t-shirt, you're going to have a refusal, because that is just ornamental. It's only for basically just for decoration. And some people they can still get through the cracks, but like I said, the trademark office is trying to come up with a streamlined process to cancel those trademarks. Because right now, if you petition to cancel a trademark, whether it be for abandonment, no longer using the trademark, or for ornamental use, then it can be very expensive. But the trademark office is very well aware of the issue that's going on with trying to register these ornamental phrases. So they are trying to come up with, that more efficient cancellation process. And I'm thinking it'll be finalized by the middle or end of this year.
Okay. That's so interesting to learn about, actually, because I feel like creatives get so confused about that stuff, or just assume like, oh, I came up with this phrase, I'll trademark it so no one else can use it. So this is really good for our audience to hear and understand. And I actually think I was looking up the trademark for wifey, the thing that I was telling you about earlier, and it did look like there was some sort of cancellation on it. So I wonder if they have kind of caught up to that and figured that one out and have, decided to nix it, because that wouldn't be permissible.
Yeah, and I know there are some phrases, if you have an actual slogan that you use, and it's a catchy phrase like that, your actual slogan,
just do it for Nike, right?
that what's actually used for branding can be trademarked. But the trademark office knows that people are trying to get away with trademarks that are not used for branding.
Yes. So like a good example would be that for Cami and I, for Biz Birthday Bash, we have something called the A to Z directory. And our slogan for that is search less, create more. Is that something we could trademark?
It sounds like it. It sounds like a slogan.
Cool.
Cool. Okay, so follow up to that, along with, I guess we're just talking about wifey mugs for now, but so you wouldn't do that as a trademark, but if someone came to you and was like, oh, I want to copyright this, how does that, would that be a copyrightable thing?
That's another good question. It would depend on what is, basically, what exactly are you wanting to copyright? Because the Copyright Office specifically states that short phrases are not eligible for copyright protection. And they do not say exactly what is the hard cutoff line. What's a short phrase? What's a long phrase? Mm-hmm. So that's obviously the gray area that everybody loves. But so if it's a mug that just says wifey, that also is not eligible for copyright protection. But if you have, say, you have the word wifey and there's like some elaborate creativity around it.
Like, for instance, wifey for lifey, no strifey, which I've never heard before. So that could be copyright, right?
Possibly. But if you have like a design around it, it can't just be like a heart in the middle. It says wifey. That is not creative enough. but the Copyright Office does have a very low barrier to creativity in order to qualify for copyright protection. But if it's just words, then it's not eligible for copyright protection. And that's because the Copyright Office, they're all for creativity and they're also for competition. So you can't just monopolize your phrase or, you can't monopolize the word or a phrase. You really have to meet their minimum creativity level in order for it to be protected. So, and like I said, that's because the Copyright Office, they are all for competition. They are all for even inspiration, but you do have to be careful when it comes to inspiration because there is a fine line between inspiration and a copycat.
Yes,
Yes.
we totally get that. So it sounds like what you're saying is the copyright refers to a specific design using that phrase, not necessarily just the phrase itself. I see so many times
Yes.
in
Yeah.
Facebook groups for Etsy where they're like, oh, I can't use the phrase mama bear because someone copyrighted it and now no other Etsy seller is allowed to use it and they're sending out cease and desist letters. And to me, that feels kind of manipulative of the system. If what you're saying is true, that it's based on more on like a unique design point and not so much of a short phrase.
Exactly. Yeah. So copyrights, if somebody says like, oh, I have this phrase copyrighted, they're mistaken. The phrase is not copyrighted. The design that they may have, that is what's copyrighted. And again, it has to meet that minimum level of creativity.
Oh my gosh, that's so subjective.
Yeah, it is.
Okay, so back to the copyright thing. I've heard that once you automatically create something, it's just automatically copyrighted by like common copyright law or something. I might have made that up. I don't know. So do you have to actually file for a copyright, or is your work like once you create it, it already has some kind of copyright to it?
So if your work does meet the minimum creativity level, then the moment it is created, it is automatically protected by copyright laws. So that's a lot of people don't understand that, and that's a big thing that they do need to understand because I have so many clients who they either wait to file for registration or they just don't worry about it. So in that case, we just submit DMCA takedown notices. And I get so much hate mail after submitting those and like, well, show me your copyright certificate. And I just send them basically just a canned message that says, this is the law. We don't have to have a registration. It's automatically protected by copyright law. And I send them information from the actual Copyright Office that I have downloaded. So yeah, I I get the same questions all the time, but you do want your registration. There's a couple of reasons for that. Number one, it used to be different jurisdictions, so different states, different federal courts had different laws on when you could sue someone. Because the big question was, can you sue someone after you have filed for registration, or do you have to wait until the Copyright Office has approved or denied your registration? And the states were split on that. So half of the states were once you filed for registration, you could sue, and the other half said no, you have to wait until the Copyright Office approves or denies your registration in order to sue. And just last week, so the first week of March, the Supreme Court actually issued their ruling because that was within the copyright lawyer community. We've been waiting on this for a while, but they finally said that you have to wait until the registration has been approved or denied in order to sue someone. And a lot of people think, well, I don't want to sue anybody. I don't care about a registration, but you never know. First of all, you never know who's going to rip you off. You never know what's going to happen. So you still want to file your registration. And if you file your registration right away, then it's typically it's only $55 for a single registration. Well, if you have an issue that's going on and you need to hurry up and sue someone, and you don't have your registration, you can file with the Copyright Office. You can file to expedite it, but that's
Mm-hmm.
like $600 or $700. So you have
Oh,
to
wow.
spend a lot more money to.
So it depends on the situation, really, if you're willing to spend that much more money. Like if it's like
Yeah,
Home Goods ripping you off, you might want to spend the money.
exactly.
um,
Yeah. So you never know. And then if you do have the registration in hand, so basically you can be eligible for statutory damages, which I don't want to get into too many details about that, but it's basically very, very favorable for you if you already have your registration and you're eligible for statutory damages. And it basically means that you have it's a lot easier lawsuit for you, and you could be eligible to recover your attorney fees from the other party if you win. So you're eligible if you have your registration within 3 months, or if you file within 3 months of publishing your work, or if you have the registration before someone infringes on your work, then you're eligible for statutory damages. So that's basically the big reasons why you'd want your registration. And again, like a lot of people, they may think, oh, I'll never want to sue someone, whatever. But I think, especially in the creative community lately, we've seen how easy it is for even big large national, international companies will rip the small designers off. So that's why it's important to still have your registration.
yeah.
So, when you a follow up question about registration, because you said the registration multiple times, and just to clarify for our audience, when you say the registration, do you mean registration for a single piece of art or registration for your business that protects your intellectual property? Can you just like define that a little more for us?
Yeah, so I'm talking about the actual copyright registration, the single registration. There are different types of registration with the Copyright Office. So the most common is the single use, and that's if you have just one, you have one design, or you have an online course and you're wanting to copyright all of the video content in there. That's one application. Another application would be the written content within your online course. And then most photographers, they qualify for um, the multi-use application, and that's basically with one sitting you can register all of those photos under one registration. So instead of photographers, if they have a wedding and they come away with 1,000 photos, they're not spending $55 per photo. It's like,
Right.
yeah, it's like 100. I don't remember the exact fee, but yeah, it's like a little over $100 to register all those photos per session. But you also, I think, were you also asking about like registering your business entity?
No, not necessarily. I just wanted to like clarify for our audience that like when you were saying the registration, it would be a registration for a single piece of art that you're like, this has been under threat by another company or by some other entity. So I registered that specifically for copyright.
Yeah.
So I think you kind of clarified that a little better.
Okay. Yeah.
Okay, I have a follow-up question too. I've also heard from other designers in the industry that they will copyright a collection to save money. So, for instance, if I did like a greeting card collection that has 6 designs, then I would submit 6 of those designs as part of a collection instead of individual works of art. Can you have any insight on that?
Yeah. So that's pretty similar to the photographer their session thing. So
Right.
there's certain requirements that you have to meet in order to register as a collection. Now, one of those requirements is that they have to basically um, they have to be connected. They have to be related somehow. So you have to be, basically the Copyright Office has to be able to tell that they are related. Basically, are they all sports themed? Are they all summer themed? So there's a few requirements that you have to meet in order to register as a collection.
Right. I gotcha. Okay, cool. That makes perfect sense because most of the things I release are in a collection anyway. So like my Christmas collection, all the greeting cards are similar, the artwork within that. So yeah, that I could just submit it as a collection and not individual. So it would be $55 for the collection instead of $55 times 8.
Yeah, so I think collections, I don't remember the exact price, but they're like $100 or
Okay.
$125. But still, if you have more than one, if you have two or more than two, then it's definitely worth it if you qualify to register as a collection.
Yeah, for
Cammy,
sure.
I feel like you need to like get on that ASAP with your adorable Christmas crests. She has this like
I know.
really cute collection of Christmas crests that feature all these like animal puns and are so unique to her. It'd be super obvious if anyone like took them and ripped them off. I feel like that would be worth your time and money to
I know, I agree.
protect them.
There's 16 different crests in the collection at this point, so I might as well copyright them, and then I can go through the process and speak to how it was and have some insight. Because I haven't copyrighted or trademarked anything, so maybe I'm just a horrible business owner, but I don't know. It seems so scary.
Yeah, I mean, no, I totally get it. Like I have clients who have literally thousands of works that need to be registered for a copyright, and they're just like, I've just waited and it's just seems so scary. But you will definitely want to check all of the requirements for collections, because I can't remember, because I don't do a lot of collection registrations. I do a lot of single works, but I think one of the requirements is that they have to be unpublished. So if they've already
Oh,
been published, then you have to file as a single use. But don't quote me on that because I don't do collections very often.
okay.
But yeah, it's all on the Copyright Office website.
Good to know. We'll link that website in the show notes, you guys, because I have no idea what it is, but Andrea will tell us later. Okay, and then so how if people are already using your work, is there other ways to protect it besides just copyright registration? Like can you just reach out to them and send them a cease and desist letter? I don't know. I literally don't know anything about legal phrases. But if you don't have something registered and someone did copy you, you can simply reach out to them and say, hey, this is my work. What do you recommend on what you do when someone does copy your work?
Yeah, so I actually, a lot of times when my clients come to me, and if it's another small seller designer, then I tell them that they can certainly reach out themselves, because they may not know. I mean, it sucks, yes, to be ripped off, but especially if they're a newer seller, they may not be aware of what, copyright infringement or trademark infringement is. And because I tell my clients, like, yes, I can send a cease and desist letter for you, and you can spend a few $100s. But if they're a brand new seller and they aren't educated, then you're basically out $350. So my letters start at $350. And because most likely we're not going to get a settlement from that other party, so it's best if you start yourself by reaching out. If they ignore my client, or if they're a repeat infringer, then I don't suggest reaching out. Then I'll handle it at that point. But a lot of times I do tell my clients, it's best if you reach out first, because that can save you money, and you can educate them, because if they just don't know, then you're saving money, and then I'm sure they'll take it down. They'll be apologetic. When they're new, they're usually apologetic. You do get those people who don't give a crap. But yeah, and if it's not a small seller, if it's not a new seller, then I do suggest sending a cease and desist letter, or you can also submit a DMCA takedown notice, which is the Digital Millennium Copyright Act, and that's for works that are hosted on online platforms. Those, you submit a takedown, you don't have to have a registration. You submit the takedown request through whatever platform, whether it's Etsy, Facebook, Instagram, Poshmark, even if it's on a Shopify website. They all have their own process because they have, by law, they have to have a DMCA takedown process. So you abide by their process, give them the information they want, and then typically within 1 or 2 business days, the content is removed, the listing is removed. That's pretty cheap. The one thing to be aware with that is the platform does provide your information to the infringer. They can and they will email you and be like, what the heck? Why did you remove this? And for whatever reason, they'll reach out to you. I get it all the time. Like, oh, I didn't know this was infringing. I designed this myself. And basically, if it's my client's work who, it's been published for several years, I'm just like, okay, maybe you designed that after looking at my client's design, but yeah, it's not original, and that's infringement.
I actually have heard of the DMCA. I'm saying that right?
Yes. Yeah.
DMCA like infringement submissions, because my brother is a YouTuber. That's what he does full time, and he has to deal with that a lot. Because people will take clips of his videos, they post them on Facebook, they make videos like mock videos, how they'll take like his content and they'll put other things on top of it, or they'll change the music. I feel like, yes, as creatives and makers that are creating physical goods, we deal with this, but digital content that's a huge like problem for that part of like the creative world as well.
Yeah, yes. I mean, the DMCA, that process is very helpful. It's just something to be aware of. If you don't have an attorney, that's definitely something you can do yourself. I submit them on behalf of clients all the time, just because either they don't have the time, they don't want to worry about it, they don't want the hate email. That's a big one, actually, because you'll never, like, it's just insane how people will just send you all kinds of stuff, like just all kinds of hate email. And it's annoying, but that's what I get paid to deal with. So,
Oh my gosh. I would definitely pay you to do that, because getting hate emails sounds horrible. And I remember I designed a logo one time, and someone reached out to me and they said that I had copied their logo, but I've literally never seen the logo. Elizabeth, do you remember this? It was like,
yes, of course I remember this.
calligraphy.
We called it
what did we call it?
We called it Laurel Gate because they were saying that you had copied the laurel, like the way that it connected to a letter. And when you looked at the two of them, it was like, yes, this is a similar idea, but they literally were like not the same at all. It was ridiculous. It was for completely different photography businesses.
Totally different business name, different state, like totally different design. Just the idea was just the letter, like the end of it had like turned into like a laurel, like some leaves coming off of the end of a letter. Like it's nothing groundbreaking. But they were so mad. That was when I first started designing, so I was so upset. I didn't know what to do. I thought I was in trouble. I thought I was going to get sued for millions of dollars. But that's a perfect segue into what do we do in those kinds of situations? Like, how can we protect ourselves from knowing whether something truly is copyrighted or we shouldn't be using a phrase? How do we check those things?
So, as far as the phrase goes, that can be very tricky because, again, if the phrase is trademarked, then you have to be careful how you're using the phrase, because when you talk about trademarks are assigned according to different goods and services. So how I explain this to people is, there's 2 Delta registrations, one for the airline and then one for the kitchen, bathroom, sink, the faucet company.
Mm-hmm.
they both have trademarks for Delta, but they can both have their trademarks with no issues because they're completely unrelated. Nobody is going to buy a kitchen sink faucet with a brand name of Delta and think that it's produced by the airline. So you have to be careful. If there's, if wifey is registered for, um, so you have wifey registered maybe for a t-shirt, then you can still use it for an online course if, it's not registered for education as well. It might be, I have no idea. So don't tell me, don't quote me on that. Like, hey, it is registered under that, but just saying, so if it's registered for goods as a t-shirt, then you can still use it as the name of an online course or the name of an airline. It can still be used in under different classes. So as long as the classes aren't related, then you can still use it. So
Is
Okay.
there so sorry, is there like a database or a place you can go to look this up? Is that publicly available, or would someone have to contact you to ask, hey, do I have access to using this without any sort of infringement?
So it can get very tricky because there is the USPTO test database, and that shows what has been submitted for application. It will show what has been applied for, what's been denied, what's registered, what is been applied and still going through the process, or what's been applied and it was never registered. So you have to know how to search the test database, because you can search for the phrase and it can come up, but if you don't know how to read the test database, then you may think that it's registered when it's really not.
Okay.
And then you may not notice just different little nuances about it. And then another thing is that trademark infringement doesn't just occur when there's a direct word match. So so use my business name, for example, Andrea Sager Law. Now, if somebody is using just Andrea Sager as a law firm, then I could go after them for trademark infringement because it is still confusingly similar.
Cami, do you want to go ahead and ask our next question?
Okay, so another question we've had is who owns the designs after you create them? Like, obviously, you're protected by copyright, but in this example, like, we create custom artwork for brides and clients all the time. So, for instance, if I created a custom crest for a bride and she wants to use it in other areas of her wedding, some clients just think because they paid for the design that they can use it however they want, and it's just free use, basically. So, who actually owns the design and when someone is paying for you to design it?
So that will honestly depend on your contract, because your contract can limit what, the contract will limit who even owns the design. So unless they're an employee, if they're an employee, then the company owns it. But if you're hired as an independent contractor, which it sounds like if, they're hiring you for their wedding, then you would own that design unless you assign those rights in the contract, which can be done, or you can reserve the rights. You could also just be licensing them the limited use for whatever you want them to use it for. So if, they tell you, hey, I want to use this crest for this purpose, and that's what you put in the contract, then they can't use it for anything else.
And what happens if they do? Because I know this has definitely happened to people where they're like, I gave so-and-so permission to use the crest on napkins and they put it up 5 other places. I mean, that gets really awkward and tricky when it's someone who's hired you for a wedding. It's like a one-time event. And it's like, do I really want to sue someone or take action over their wedding day? Like, what's supposed to be the happiest day of their life?
Right. Yeah. So in that case, technically, yes, you could sue them or, send a demand letter like, hey, the contract said you could use it for this. You used it for this, this, and this. So you owe me, this amount of money. Or
Okay.
if you want to be proactive about something like that, maybe just charge more and just say, okay, you can use it for everything in your wedding instead of just this one limited purpose.
Yes, I really like that idea of giving like the extended use and kind of having the money ahead of time, because then it's not the headache later when it gets used in a million ways that it's not supposed to. But I don't know.
I think one of the big issues is they just don't understand that they are purchasing. They don't understand like the terminology. So they're purchasing a license, and they're purchasing a license to use your crest or your design for whatever, the one thing that they asked for it. But they think, okay, I purchased it from, this designer. Now I own it and I can use it for whatever I want. That's not the case, but they just don't they normally just don't know, because it's not very intuitive. It's just
Mhm.
something that you have to learn. So either you could charge more and let them know you can use it for everything, or just spend more time upfront educating them about, you're purchasing a license to use it for this. You can't do this or this with it. If you do want to use it for that, then it costs extra.
Okay.
Yeah, that's both of our contracts protect us from that. I mean, yours does, right, Elizabeth?
Oh,
I
for
can't
sure.
remember.
Yeah, I owe all my art.
Yeah, that we own all of our art and that it can be used however we want because we're the owners of it. And then if they want to purchase an extended use contract, I have that available as well. So they can, if they did want to use their crest and not print it through me, I don't charge for them to reuse it really to print it through me. But if they wanted to reuse it, like this is if I did their wedding invitations, then I have an extended license contract. They can purchase that and use it for either one thing, or I sell like an unlimited one for more money that they can just have it and use it however they like. But all my custom crest designs, my website just already include that they can use it however they want. Like, because I'm not designing anything else for them, and they are at a higher price point, so I feel like it covers me, and I don't feel bad about giving them the extended license to print it however they would like. So, yeah, definitely something to keep in mind and make it very clear on your contract that you do own your artwork. So,
Yeah, that's a big one.
Okay, so along those same lines, how else can we protect ourselves and our business? What types of contracts do you recommend for stationers, artists, designers to have?
So it definitely, I well, one thing's for sure. I definitely suggest your event contract or your main sales contract. Definitely have that reviewed by, a local attorney, somebody that's in your state, because they will know your specific state laws and what you can and cannot get away with. Because sometimes, like maybe you will have, you found this contract online, you think it looks great, it protects you, but some states have specific laws that may void out a provision in your contract. So it's definitely worth having a professional look over it, just to make sure that it is fully enforceable. And I mean, these days you can find small business attorneys to look over it for, I mean, a couple of $100s, no big deal. Another thing is, inevitably you're going to have issues. You're going to learn from your mistakes. You're going to learn from different contracts that you have, different um, people that you work with. Keep a running list of all of the issues that you have, because you'll want to implement all of that stuff into an updated contract. Because I get people all the time who come to me and say, hey, I have my standard contract, but I've been keeping a list of things that I want to add or change. And it's very helpful when they know exactly what they want to protect themselves from, because sometimes, I mean, most of the time, you don't know what you don't know. So you're not going to encounter these issues until they actually happen. You're not going to know about the issues until they actually happen. So it's really important to actually keep a running list of issues that you have with your own contract.
I do have a question really quick. So a lot of us as stationers or artists in general work with clients across state lines. So I'm in Georgia. So if my contract is, in accordance with Georgia law, et cetera, what does that look like if someone from like New Jersey or California is signing it? Are they still held to the same standards, I guess?
Yeah, no, that's no big issue. So assuming that they are reaching out to you, they know that they're, contracting with someone in Georgia. And your contract most likely states if there is an issue, then, the choice of forum or choice of venue that will be in Georgia. So
that is something I would need to add.
Yeah, because otherwise, it would just default to state law. And in that case, if you're working with someone across state lines, then the question is, okay, whose state? So,
right.
Yeah.
Right. Okay.
Oh my gosh.
Yeah, I'm gonna say, Cami, I'm willing to bet you probably don't have that in yours right now either.
Oh, no, I don't. So that's definitely something I need to add. Well, you don't know what you don't know, you guys. Oh, but Andrea, you also have this amazing contract vault on your website. Can you just tell us about this? Because I literally just downloaded it this morning and my mind is already blown.
Me too. I downloaded it yesterday and then we felt bad that we didn't send you a podcast contract.
No big deal.
No. We're so embarrassed, but you're our first guest. We don't know what we're doing.
Yeah, so when I started out on my own, I wasn't trying to do everything, but whenever you're starting in business, you're doing everything you can to make money. And one of those things I was doing was selling DIY contracts. Well, now that I'm more established, more niched down into copyrights and trademarks, I've created this vault. The small business contract vault is something that I created in order to really reach more of a larger audience. It has a podcast consent form, the guest consent, which isn't always necessary, but it still provides. It just eliminates questions. It outlines expectations for everybody involved. There's an independent contractor brand rep agreement. There's an influencer agreement. So if you're a products-based business and you work with influencers, there's a great agreement in there for that. It's really just several contracts to really help small businesses, and it's free. So you can download it without any charge.
And where on your website is that? I'm looking at your website, but I'm sure you have a specific link where people can go. And we will be happy to link that in the show note, guys. But where would people find that, Andrea?
It pops up whenever you go to my website. So if you've already opted in and received it, then it won't pop up for you anymore. But I do have the link that I can give you guys as well for the show notes.
Yes, that'll be perfect because I know people will be super excited about downloading those and adding them to their armory of things that they can hopefully utilize in the future. I mean, I definitely know Cami and I are going to utilize that podcast one going forward. I mean, we were just laughing at the irony of it. We're like, of course, our first guest is a lawyer. And of course, she has this awesome podcast agreement that we didn't even, think about using. But gosh, we're so thankful that you took time to walk through all of this because this is just such a headache for people in our industry.
I know. I feel like I learned so much today, like so many things that I didn't know, even just the simple definition between a copyright and a trademark that we all just get so kerfuffled about. But now I just feel like I have such a clearer picture of how to protect myself. So this was so awesome. Andrea, you are amazing.
Thank you
so much.
I had a lot of fun.
Yes,
Good.
we're so glad you were able to hop on and join us before you have your baby. Oh my gosh, you guys. Andrea is literally about to have a baby in like 3 days. So
Which is so funny. By the time this airs, I guess the baby will be a month old. So congrats ahead of time.
Thank you.
All right. Well, for all of those of you who are listening, who would love to have that link to get those contracts from Andrea's website, make sure you check the show notes of the episode. We put all of those on bizbirthdaybash.com, but we'll make sure the link is in the description that you find on iTunes as well. But I think that kind of concludes our episode for the day. Thank you so much for joining us, and we will see all of you guys next time.
Bye.
Bye.